Good morning, everyone, and welcome again to our latest webinar, this one on reopening again. And I wanted to open with a few items. First, housekeeping, letting everyone know that, as I've said in the past webinars, this is an interactive event. We're hoping that you will ask questions. We're hoping we'll be able to answer those questions. I believe, well, I'll talk more about this in a minute, but I believe you can chat your questions to us, and Jonathan Silverman, who I'll introduce in a minute, will be taking those questions. I think chat function is on the toolbar, and if you have any other questions, you can also email or text them. Just let us know. Second, I want to mention in a little bit more detail that this event will be broken up into 3 sections. Last time we did 4, this time we'll have 3. Each section will be approximately 15 minutes, and we're going to leave hopefully about 10-15 minutes for questions at the end. As we've said before, although it's a serious discussion and we're discussing serious matters, we don't take ourselves too seriously. So please, we want this to be light. We want it to be interactive. We want you to enjoy it, and we do hope that you'll participate. Let me begin by introductions. My name is Gary Silverman from the law firm of Silverman Theologu. I'm joined today by my law partner, Milt Theologu. How are you doing today, Milt?
Doing great, Gary. How are you?
Great. Thanks for joining me. Also joining us from our firm is Diana Theologu. Diana, glad to have you with us today, first timer.
Good afternoon.
Rounding out our speakers panel is Seth Behrensweig from the law firm of Behrensweig Leonard. Thanks for joining us again, Seth. You're an old timer.
Thanks for having me.
And then, as I mentioned earlier, Jonathan Silverman from the Capital Group will be leading the Q&A. He'll be taking your questions, and at the end of the presentation, we'll be getting to those questions. So let's get started with the first slide. Rob? Great. So as we had talked about in previous events, initially we had discussed what reopening would look like, what closing would look like, what reopening would look like again, because this really seemed to be all over the place. So now we're looking at an overview of June, July, August, and then into September, and see where we were and where we're going. So if you take a look at what we have up here and then slide up here, you'll see that the July reality check, and we did the same thing in June and did the same thing in May, you'll see that again, with recent polls, and these polls are ongoing, people are spending, again, most of the money they're getting from the stimulus and in any other manner they're getting funds to pay down debt, to buy consumer electronics, to add to their savings, but certainly only about 15% are using funds for necessity. This is important when you consider as a credit union how you're collecting debt and the means by which you're collecting debt. Another data point that I wanted to update is unemployment. You'll see here, and this is a recent poll taken in late July, is that unemployment, where the expectation was 25 to 40% back in April when we first started doing this, the unemployment rate now stands at 11%. And if you look at the slide, you'll see in certain states in the Mid-Atlantic where we are, that's averaging about 8%, Maryland, Virginia, DC. And the higher averages are obviously in the hot spots in New York, New Jersey, California. I would venture to guess if I looked at it today, it would probably include Texas and Florida as well. Last point on this bullet, I just wanted to talk about, and again, seems to be the case, is that if federal employments were to end and folks were forced to go back to work, it was predicted that unemployment would probably go down to about 6%. I think that number is probably even lower now. At last I heard, it was probably about 5%. So as governments and businesses struggle to try to figure out what's next and people continue to be polled about what they want, we'll talk about what's going on in legislation in a minute. The one poll you see across the board is most folks want to see those stimulus checks continue, those unemployment checks continue, because they want to make the choice as to whether they go back to work, given what's going on with the rollbacks and given what's going on with the pause. I think it's great that some states are calling this rollback and some states are calling it pause. It seems to have the same effect. So today what we're going to do is look at 3 topics. The first that I'm going to cover is opening and rollbacks. legislative action, and then a look beyond. Our next group is going to cover the phased reopen and legislative action, and then we'll cover resources and best practices as states and businesses struggle to reopen. Next slide, please. So one of the things I wanted to do was take a look at where we were. And if we take a look at where we were, you'll see that back in June, it appears as though we were flattening the curve. I took mid-Atlantic states because they seem to do the best job of this: Pennsylvania, Maryland, the District of Columbia, and Virginia. And when you look at those jurisdictions, what you see is that they did a good job of keeping things closed. They did a good job of slowly reopening. They did a good job of keeping the restaurants closed or to low capacity with mostly carry out. If you look at Pennsylvania, they didn't start reopening until July. In mid-July, they changed capacity to what people could and couldn't do. And then most recently, put in new orders on social distancing and face coverings. I'm going to skip Maryland and go to the District of Columbia. The district was one of the last states to reopen, and in June put a second round in place for reopening, but again, only opened restaurants to 50%, and again, put orders in on social distancing and face coverings. Virginia was a little bit late to this party. They did not institute a lot of these closings. They are now starting to do more. Mid-July, what we saw was Virginia started to mandate wearing face masks. Anecdotally, I live across the Virginia border and in Maryland. And so what I see is I drive around Maryland and see everyone wearing face masks. And I go to Virginia and see that maybe some folks are starting to wear face masks indoors. Outdoors, you don't see as much of it. In Maryland, what's interesting, and I want to go back to that, is that the governor of Maryland, we think, did a fairly good job of making sure that things were closed, stayed closed, and opened very slowly. What the governor did in Maryland was leave things on a county by county basis so that counties could make a decision as to what they wanted to do. And here in Maryland, Baltimore, Anne Arundel, Montgomery, Prince George's have been very slow to open because of the number of cases. And if anyone saw in the news yesterday, the governor of Maryland actually didn't roll anything back, but he did put a plan in place for additional face coverings and required people to now wear face coverings everywhere, and I believe almost all the time. I think from something like either 2-year-olds or 5-year-olds up. So you can see that even in states where in June they were doing a good job on talking about reopening and hoping to get to reopening, even those states are starting to roll back a little bit. Next slide, please. So as you can see, July appeared to be the rollback month. I guess the data point that was most important to me, which is the one I highlighted, lawyers like to highlight things. 40,000 new COVID cases were reported in one day at the end of June. And what you'll see is because of that, July really brought us to rollbacks in a lot of states. So the key states I'm sure that you're all hearing about or reading about are California, Texas, Florida, New York, where the cases are just growing exponentially. I'll go through this a little quickly in the interest of time. In California, the governor ordered 7 counties, including Los Angeles, to close bars. In Texas, where they reported a 79% increase in COVID cases, the governor of Texas, again, closed all bars, but left them open for carryout and delivery. And I've been to Texas. I'm not really sure you're going to the bar for the food, but if they can remain open that way, it's great. But they've been hurting, and the governor of Texas just said the number of cases that are coming out in that case and continue to grow is requiring them to do this. In Florida, which is very interesting, notwithstanding the fact that they are getting a high number of cases, they've restricted the number of people who can come in or required to self-quarantine from states like New York, New Jersey, and Connecticut. They've closed down short-term vacation rentals and are imposing a fine on folks who do not self-quarantine when they come in from other states. So I guess what you learn from that is if you don't want to self-quarantine for 14 days, they'll be happy to quarantine you for 60 days in jail. In New York, something similar. They've started to reopen, then started to reclose, put 31 states on a hotspot list, and determined that if you come from those states, you need to self-quarantine. Folks arriving at airports in New York now are required to fill out a health department traveler form or face a $2,000 fine. It's not in here, but just so you also know, DC just imposed a similar rule in that if you fly into the District of Columbia now, you're required to self-quarantine for 14 days. If you look at the slide on the US government, what you'll see is Dr. Fauci has talked about states potentially rolling back from phase 2 to phase 1. He cited a number of states that should think about doing that. And then finally, in business news, you'll see, and this is the big news for our family at least, Disneyland Resort in Anaheim will not reopen, and they don't know when they will. Disney World in Florida has reopened, but on a very limited basis. You can also see that Apple announced that it was closing stores in states that are spiking. The states are listed down there. You'll see other businesses doing the same thing. Next slide, please. So let's talk about what's going on in legislation. So as everyone knows, and you've seen on the news over and over and over again, on May 15th, the House passed the HEROES Act. They've actually got to have someone who spends all of their time coming up with these acronyms. The HEROES Act, which is the Health, Economic Recovery, Omnibus, and Emergency Solutions Act, is laid out here. We talked about it at the last event as well. House lawmakers passed a $3 trillion bill extending emergency family leave, adding another round of payments, which is up to $6,000, extending federal unemployment, adding hazard pay to frontline workers, directing nearly $1 trillion for states, and adding $200 billion to pandemic hazard pay for workers. The response from the Senate and the White House is listed here. The Senate Majority Leader called the bill a seasonal catalog of left-wing oddities and an unserious effort. The president signaled that he would veto the bill. So fast forward now to July with approximately a week left for Congress to come up with some bill that they can agree on. We are now brought the HEALS bill by the Senate. This is their attempt to reconcile the HEROES Act. I'm not really sure how that will work. There's a lot of movement on this, and what we're seeing in their bill is another stimulus for Americans, probably in the neighborhood of about $1,200, continuing federal unemployment benefits. No one knows what that's going to look like, either a flat amount or potentially 70% of salary replacement, a return to work bonus, and aid to schools, moratorium on evictions. Pretty much many of those things are what you'll see in the HEROES Act. Another round of PPP, which is something new, and of course, something the Senate is requiring in their bill, a 5-year liability shield or protection for businesses that limit COVID lawsuits. It seems, well, I was going to say, and you look at the last bullet, it seems that there needs to be a stimulus bill passed because unemployment is ending and a lot of this money is going away. I felt very comfortable saying that last month. I don't know how comfortable I am saying it right now, but we'll see what happens, and we'll certainly keep everyone updated. Next slide, please. So where does that leave us? And the reason why I wanted to go through all of that, because putting in context what's going on in the world helps us put in context what we're trying to do. So if you take a look at what credit unions need to think about on the reopening and the rollbacks and the options, and the collection optics, you need to give some thought to what does the world look like outside? What does the world look like to everyone around, to the members, to folks coming into your branches, to your employees? And then how do you reconcile that to what we need to do as credit unions, as management, to make sure that we move forward? So, going forward with just a few of these bullets, and I just want to go through it quickly again. When polled, Folks are using money to pay down debt. Unemployment continues to go down, although it seems to be hovering around 10, 11%. And 80% of Americans want to see more money from the government to keep going. It seems as though phased reopening seems to be based on more people's desires than it is based on medical professional recommendations, although with the pause and rollback, we're obviously seeing that move back a little bit. Hospital systems continue to be overwhelmed, which again is why many states are pausing and rolling back. So what do you as a credit union, what do we as working with credit unions do when folks want to work with us and want to come into branches and want to see us, but still we're stuck in a position where states are rolling back and governors and counties are trying to make hard decisions as to what to do. So as you hit the pause button, as many of our clients have, on accumulating cases and making determinations on referring cases for collections, one of the things we think you need to look at is what does your bad debt portfolio look like when you hit the start button? Many of our clients, again, are accumulating cases, holding cases, not referring cases. What are the optics of when you start to refer that, what that looks like? If you have 1,000 cases, 2,000 cases, how do you refer those? When do you refer those? Do you stagger it? Do you do it differently? Do you send them in batches? It's things you need to start thinking about. My guess would be come September time, people will start to think hard about those decisions they need to make. Given court closures and court inactions, Milt to talk about that a little bit more. We need to start thinking about when you refer cases based on when they'll eventually get to court. If you're thinking, I'm going to refer cases next week, they're going to get to court in a month from now, that simply isn't the case. Again, Milt will talk more about that. So lastly, I would suggest that as the pandemic continues and the number of cases rise and bad debt rises and potentially bankruptcy rises, Diana will speak a little bit about that, what do you need to do differently to resume collections, repossessions, foreclosures when they come back online? What does your staff need to look like? What do your policies need to look like? And what's obviously going to be a new economy and clearly going to be a backlog of cases that you have that you're going to need to refer and send to lawyers or send to collection agencies, wherever you do, so that you have some flow and it doesn't create bad optics of sending out all these cases at once. We've also put at the bottom of this some of the helpful links on reopening from the U.S. Chamber of Commerce, and I believe that's a New York Times phased reopening. It is New York phased reopening link. Please take a look. If you have any questions, let me know, let us know. And as my time is up, I'm going to hand it over to Milt Theologu. Milt?
Thanks, Gary. I'm going to spend a few moments talking about the courts and the impact that these closings and reopenings have had. Primarily, what we're seeing is that courts are slowly to reopen, or they're taking their time, but they are reopening nevertheless. So far, there haven't been subject to any rollbacks, but that's yet to be seen. So if we can move on and we can look at what the courts look like, we'll get a better idea of where we are. Maryland is still pursuing a phased approach. We are currently in phase 3 of that process. Courts are open, but they're really not handling any contested matters. It's mostly procedural matters and things that can be handled by attorneys solely. Although civil non-jury trials are not scheduled to begin until phase 4, certain jurisdictions, mostly smaller and rural jurisdictions, are scheduling trials earlier. If the current phased approach continues and is not rolled back, we should see in-court proceedings and in-person hearings come September. In DC, the courts are open. However, there are no civil collection matters. Recently, earlier this month, I should say, the DC mayor extended the public health emergency till October 9th. Now that is important to us because that means that we can't file any new collection filings or pursue any collection other remedies in court until December 8th because of the 60-day moratorium or 60-day extension. Instead, we have to place all those files on hold. Now, what does that prohibition mean for you? In a short word, it means nothing. You can still contact your members directly. You can still send letters so they can pay their delinquencies. All it means is that your lawyers can't file anything new in court. So for your internal collection and credit departments, they should keep going and still keep pursuing those delinquencies. In Virginia, the courts are open to some extent, but because of the decentralized decision-making process, depending on certain hotspots in the states, certain courts are making the decisions to roll back or not. What you need to know is that for Virginia, everything is still moving forward. We haven't had any word back from the governor that the courts are closing, or from the Virginia Supreme Court that the courts are closing, but we should keep an eye on it on a jurisdiction to jurisdiction basis. Now, at the bottom of the slide, there's a website. We will make that available as we've done in previous seminars, so you can check different prohibitions and different limits on other states. Now, if we could go to the next slide. When we do come back to court and when court starts hearing matters, there's going to be both remote and in-person hearings. Now, the courts are generally adhering to the following guidelines. With some jurisdictional exceptions, remote hearings will be limited to procedural matters, such as pretrial conferences and scheduling conferences. Additionally, non-evidentiary hearings will be held remotely. What does that mean? It means hearings that do not require a witness to appear and provide testimony. Those will be going forward. These may include hearings such as motions for default, motions to dismiss, and motions for summary judgment. Barring any further rollbacks in the court system, we will eventually be moving towards in-person hearings. But even in the current situation, the courts are scheduling limited in-person hearings. For the time being, these in-person hearings are generally limited to non-contested matters, such as evidentiary motions and ex parte hearings. As we get further along, courts will begin scheduling contested trials, first non-jury trials, and then eventually jury trials. But in most jurisdictions, we're not there yet. So you might be asking, what will going to court look like? So if we can go to the next slide, we will see that the courts are taking extraordinary measures to keep court personnel and the public safe during this pandemic. Now, you may remember pictures or your own recollection of crowded courthouses and courtrooms, but that is not going to be the case as we start reopening the courts. So what should you expect? Well, when you're going into court, you should expect screening questions, temperature checks. There will be social distancing, not only in the courtrooms, but throughout the courthouse. There will be limited access to courtrooms. For example, only attorneys and witnesses for cases on the docket are allowed in the courtroom. This will allow courtroom staff to disinfect after each docket and to keep the public and court personnel safe. Because additionally, the courts will be spreading dockets throughout the day. Whereas before you would either have a morning or an afternoon docket, the courts have decided to schedule to spread out the dockets, which will eliminate the need of crowded courthouses and crowded courtrooms. Because of the spreading out of the dockets, there will be fewer in-person court appearances for the foreseeable future. So you're not going to be going to court right away. But if you do have a scheduled hearing, you must be punctual in order to avoid your case being dismissed. Because of the multiple dockets, courts are going to be as lenient when people come in late because they have a tighter schedule to meet and tighter circumstances to deal with. Now, obviously, these steps that courts are taking will not affect the current pending litigation, but it will also have impact on future filings. So if we can go to the next slide. In this slide, we'll examine the effects of courthouse closures and the gradual reopening on current and future cases. In Maryland, affidavit judgments entered between March 16th and July 20th have been vacated. That means that those cases, even if judgment was entered, will be rescheduled for affidavit trial dates. And those affidavit trial dates are being set currently. In Virginia, cases are being rescheduled by the courts, but unlike the normal process where the attorneys schedule the court hearings, now the courts are taking over that responsibility. That creates scheduling conflicts and may push back additional hearings for cases that are already pending. In DC, as we've talked about before, there are no civil collection filings. Small claims hearings on the collection calendar have been canceled, and large claims are only moving remotely. So there won't be any in-person hearings in DC. Now, what has all this done for future filings? Well, it's really just backlogs and delays. There'll be a delay in processing new filings, obviously. There'll be a delay in scheduling trials. which will ultimately lead to a delay in getting judgments. In DC, depending on when the courts reopen for collection matters, it may be at least a year until we can start clearing out some of these backlogs and starting getting to some sort of normal operations, because the court will not only have to deal with the backlog of cases from March, but also what is expected to be a deluge of files coming in to the court system once the floodgates finally open. So the best practices that we recommend at this point is to refer cases in all jurisdictions now. Because these backlogs will inevitably occur, you want to be ahead of the game. You want to have your cases ready, so when we can proceed, we will be able to proceed. You don't want to have a situation where cases linger and collections linger, because as we all know, a debt that lasts or is out there for longer is harder to collect. So in order to keep down delinquencies and to keep these collections moving, our recommendation is to refer now. Now, on the next slide, we're going to be talking about repossessions and garnishments. Now, there are no prohibitions against self-help repossession in most jurisdictions where we practice. The exceptions obviously being Maryland and DC, where the ability to begin repossessions are tied to the public health emergency declarations by the governor and the mayor. So when it comes to repossessions, you can proceed as normal depending on the jurisdiction's statutes and rules regarding repossession and bankruptcy. Repossession and garnishments. When it comes to garnishments, there are provisions in DC as well as in Washington where garnishments are being accepted. However, they are not being processed in a timely fashion. In other words, certain court clerks are holding on to them or sitting on them, depending on how you want to say it. What that means is that although they're accepting the filings, they're not being processed in a timely fashion to be sent out to the employers or the garnishees, so we can get a return and actually find out if any funds are being held. What that means to us is that we have to file these ahead of time and allow for more time for processing, which again adds to the delay we talked about previously. Now, there's current litigation being debated in Congress which would make garnishment funds protected, much like Social Security funds. Obviously, this is an evolving situation and we'll keep our eye on it, but really what we need to focus on is getting these cases in and getting them out the door in order to assist you and your credit departments in collecting these delinquencies. Now, I'm going to throw it over to Diana, who can talk to us a little bit more about foreclosure and bankruptcy. Diana?
Thanks, Milt. I'm just going to go over in broad strokes kind of the federal guidelines. So the federal government, as you know, insures loans through FHA, VA, Fannie Mae, Freddie Mac, and they have put a moratorium on foreclosures and evictions through August 31st, 2020 nationwide on all of their loans. What that is interesting is because the eviction moratorium is not just filing an eviction against a former homeowner that was foreclosed, but if the landlord has a loan with Fannie, Freddie, FHA, or VA, they can't evict their own tenant without following the regulations and the moratorium. Most states, including Maryland and Virginia, are requiring additional affidavits affirming you've complied with the CARES Act or that the CARES Act is not applicable for whatever reason. Reasons can include if it's an estate, someone is deceased, obviously. If it's vacant property, there's other issues, of course. But the interesting thing is these moratoriums apply whether they're vacant or not, whether it's commercial or residential across the board. So it's very interesting. The state moratoriums, I've outlined 3 different ones, Maryland, DC, and Virginia. Maryland's foreclosure moratorium that was set by the courts was lifted as of July 25th, 2020. However, the governor issued an order closing down the office where you have to register notice of intent to foreclose, which is required to be done within 5 days of sending the notice of intent to foreclose. Therefore, the governor has, for all intents and purposes, instituted a moratorium himself. It is tied to the state of emergency. So right now, it would expire July 31st, but every single month since this has started, Governor Hogan has religiously extended the moratorium by 30 days for each and every month. I think July was the only one that he did on the 2nd instead of the 1st, but he's been very good about that. I don't anticipate that it'll end July 31st. Governor Hogan gave a speech yesterday. He's now requiring everyone to wear masks, even at family backyard barbecues. He's talking about potentially rolling back to phase 1 or stopping at phase 2 instead of moving on to phase 3. Therefore, for all intents and purposes, he is most likely going to extend that moratorium to August 31st. I would anticipate it might be longer than that, but there's no way of knowing for sure. DC, the foreclosure moratorium is now tied right with the collection moratorium. I'm not going to go into that because Milt did a lovely job of going through the DC moratorium, and it's 60 days beyond the emergency declaration, just like collections. Virginia never really had a moratorium. Their moratorium, or their legislation that they put forth, you can only hold a foreclosure sale if the courts are actually open. So when the courts were closed, there was a foreclosure moratorium because you couldn't hold a foreclosure sale. However, once the courts open, there is no moratorium. That being said, the governor in Virginia has taken several measures to provide residents of Virginia assistance. There is a website they can go to and apply for state assistance if they're having difficulty, but foreclosures can move forward as if nothing is going on in Virginia. If we could move to the next slide. This one is just about bankruptcy. So bankruptcy courts are open. Hearings are telephonic or through conference calls. There's not a lot of evidentiary hearings in bankruptcy court, so they're moving forward as scheduled through conference calls and zoom.gov. It's actually a little easier on me as the attorney to attend. I don't have to drive everywhere. The court did initially issue orders extending deadlines to object, deadlines for debtors to file things for 87 days due to the pandemic. However, those extensions have passed. Discharges are being entered. Motions for relief are moving forward. That's all going smoothly at this time. Proof of claim deadlines themselves were still in effect and not modified. You need to keep filing the proof of claim timely. If the proof of claim is objected to because it was filed late, because the credit union or other entity wasn't open to receive the notification, we would need to defend an objection to proof of claim based on that. Courts are routinely granting extensions, of time for missing trustee payments. So the debtors are required to make payments in Chapter 13s, Chapters 11s, Chapter 12s, and they of course don't have the income. So the courts are granting extensions of time for them to make up those missed trustee payments. A lot of the debtors through counsel are filing motions to modify the plan, and they're even allowing them to extend their plans up to 6 months past the statutory maximum of 5 years. Just so if you see, hey, I'm not getting payments, on this claim, what's going on, that could be a reason why. I will note, I am still a member of the Consumer Bankruptcy Council here in Maryland, and I have seen debtors counsel indicating that they're expecting a sharp increase in bankruptcy filings, similar to when we had the crash in 2006, 2007 with Chapter 13s. However, any Chapter 7s that they're currently getting, they are generally holding on to them and not filing them because those debtors are still incurring debt because they're not back to work. So they're waiting until the issue is resolved before they file those Chapter 7s. So keep that in mind if you see somebody having a lot of difficulty that they may be preparing to file bankruptcy. Also, if they do come back and say, hey, I filed bankruptcy, there are ways to check and see, did they know they were going to file before they took out that loan? And you can object to the discharge in those instances, and you can contact our office.
You're done.
I'm going to go ahead and pass things off to Seth Behrensweig.
Hey, Good day, everybody. It's a pleasure to be here. My name is Seth Berensweig, and I'm the managing and founding partner of Berensweig Leonard. We're a business law firm here located in Tysons, and I'll be talking about a variety of issues that we see in working with our clients that are largely employers in the region and nationally, and seeing how things are developing and helping them navigate through the complexity of the COVID crisis. I'd like to start off by zooming out a little bit and taking a little bit of a high level view in terms of where we are today. This will have a minor overlap to some of the things that Gary touched upon earlier. But I think it's safe to say that in terms of where we are now from a big picture perspective, the hopes of some kind of a broad opening anytime within the next half year have essentially faded. And what we're also seeing is that the administration has basically entrenched itself in what is essentially a state-led model, where the federal government has made a determination that although they're going to be issuing regulations from the CDC, which quite frankly, the administration is internally bickering about on a weekly, if not daily basis, this is going to be a problem that's going to be handled at the regional and the local level. And therefore, what that means is that you're going to be wanting to view from both an employment, unemployment, and enforcement approach, how things are going to be applied to your business and the business decisions really on a local level. So for example, if there's going to be any orders with respect to regulations or opening or handling of certain regulations, they're almost guaranteed to continue to be wholly on a state and on a county-based level. And what this also means is that the pressure that's going to be placed on Congress to come up with some kind of a solution by this weekend's deadline to extend the vast array of federal unemployment and related benefits is going to be increasingly highlighted, because right now what we have are a lot of dueling sarcastic comments and fingers pointing at each other on Capitol Hill. But frankly, there's really no solution in sight. So what employers are looking at now for at least the rest of this year, there's going to be no federal leadership from a national strategic standpoint for at least the next day or two, if not longer. There's not going to be any leadership from Congress in terms of any legislative solution. And therefore, unfortunately, we're really just going to be left to kind of duking it out for ourselves on a state and local level. So what I'm going to do now is, having set that context, I'm going to explain to you some of the things that you need to be aware of, plans and policies you need to have in place so that you're protected as best as can be in this challenging COVID environment. If we could please go to the next slide. One of the continuing recent realities right now is that schools will continue distance learning for the fall. And this is something that is going to have a profound effect on the running of American business and the recovery of the American economy. Working parents in the United States are facing unprecedented pressures. And unfortunately, they're not only learning that they're going to have to be continuing to wear multiple hats, and including helping educate their kids, but they're learning late in the game as to whether or not, or the extent to which their kids are going to be integrated and involved in the school process. So what this means as a practical level for employers is that they're going to have to recognize that for at least another half of the year, they're going to have to approach telework solutions as a long-term situation. Nothing's going to change in an immaterial way for at least the next 6 months. And what this means as a practical matter is that communications and conveying communications and information from employee to employee and also from company to customer are largely going to continue to occur online. From the perspective of financial institutions, the data continues to reflect that what that has resulted in, unfortunately, is an uptick in activity from cyber criminals, and that data protection and cybersecurity now are going to be facing an increased emphasis. It's also noteworthy, however, that although data protection and cybersecurity is something that you are going to be held directly responsible and liable for. Once again, our friends in Washington have no federal plan. Ironically, there was a hearing yesterday with technology leaders, and they ended up talking about a lot of issues, but they really didn't talk about data protection, cybersecurity, nothing that's being led on the federal level, which means that everything's going to be teed up on the state level, which also means that states have their own regime and their own liability mechanisms and compliance requirements that you need to be aware of, because there is no federal plan. It's only state. What that also means is that although you should be having a written data protection and cybersecurity policy in place at your company, at the credit union, the requirements and the contents of that are dependent upon the jurisdiction in the state in which you are. And really a lot of companies are not aware that there are these state requirements for a written data protection and cybersecurity plan. B, they're not aware of what the consequences are for not following that. And honestly, it's totally understandable, because you're there to run your business and manage your HR resources. But the question that I would ask you to consider today is, do you have a data protection and cybersecurity written in place, either on the shelf or in your computer in a folder? If you do, then that's great. If you don't, then data shows that this continues to be an area of heightened liability protection. And when there's a time that comes up where there is going to be an intrusion or an incident, you're going to need to be able to demonstrate later that you have that written plan or policy in place. Let's go to the next slide. Let's talk about another area that really kind of punches companies in the gut during this COVID crisis, and things that we need to be aware of. One of the issues that Gary mentioned that's really critical is that one of the issues Congress is looking at, although they're just doing more arguing about it than agreeing about it, is the issue of employer liability protection. That's going to be really critical, because companies are really scared right now that the lawyers are going to come pouncing. And unfortunately, I think that that's not going to be alleviated until we have any kind of employer liability aspect that's going to be coming out of Capitol Hill. As we sit here today on Thursday afternoon, literally a day or two from the elapsing of these crucial federal benefits, there's absolutely no consensus whatsoever on Capitol Hill. And even within the Republican plan, as Gary said, the president's even pessimistic of that. So what has happened is that, again, employer liability issues regarding COVID infections and disease have really been defaulted to the local and the state level. And that's created a lot of uncertainty with regard to how you're going to be able to protect yourself and how the courts are going to respond to it. One of the common themes of cases that have come up that you need to be aware of is the so-called nuisance cases, where employers have sued, for example, McDonald's and some other outlets and employers, saying that a less than pure economic environment is a public nuisance. Some states have said that they agree with that. Other states have rejected it. It's just a trend that you need to be aware of, and it really is applying on a case-by-case basis until Congress deals with that. The states, in leading the way, have decided and realized that the only way that we're going to get any kind of guidance in terms of specific explanation of what needs to be done in the office is for the states to do it, because basically states are on their own. Days ago, Virginia enacted the nation's first workplace safety mandate. It was issued by the Department of Labor and Industry in Virginia as an emergency measure that applies for 6 months, but that will likely be extended. It's the first in the nation. It applies several various criteria, depending upon a categorization and the nature of the workplace, the categories of employees, what their responsibilities are. There's requirements for education, training, communication. There are significant fines that are imposed, and it's very broad. Now, some of you may say, well, this is really a big deal for us, because although we have a couple of remote people in Virginia, we don't have an office in Virginia. Well, I'm sorry to report that if you have anybody in Virginia, even if they're working from their home, you're subject to this. So I would respectfully suggest that you take a look at that. If you have any questions, of course, you can contact any of us afterwards. But this is a brand new requirement that has come into place And there are other states that are now going to be following this model. Oregon has already looked at it. Other states are as well. The question is, do you have a return to work policy, which includes a workplace safety plan? If you do, that's great. If you don't, you need one. And I would recommend that you speak with your legal counsel and get that together, because that's going to be crucial in order to demonstrate that you are not only following best business practices, but that you understand what the regulations are at the local level so that you can avoid significant fines. Let's move to the next slide so that we can just keep speeding right along. We're going to be talking now a little bit more about HR management. The employees are the most critical asset of the company, and HR management continues to be a very tricky issue that we're seeing for all of our clients. The more frequent the communications with the staff, the more successful we see the organization. We are encouraging the company to designate either to continue to empower or to designate a head of human resources on staffing communications. I think that's really key, and to make sure that your HR lead is in contact with your legal counsel, so that if there are a lot of these issues that come up with regard to how to handle leave, how to handle accommodations, how to handle illnesses, how to handle PPP forgiveness, that you're constantly on top of this. Because remember, and we're not even really going to cover this today, but in the background, you still have PPP that's rolling and wrapping up. You have PPP forgiveness. You have employee furlough and capital preservation issues, and having someone who's designated as an HR lead is going to be critical. Continue to follow CDC guidelines, but as we noted earlier, you have to look at the local and state level as well. And you want to make sure that it also addresses customer safety naturally. And a lot of the financial institutions that I've seen have dedicated a lot of new infrastructure and plexiglass and so forth to continue to engage in best practices. One of the issues that we see coming up, and one of the aspects of this seminar that we really want to make sure is that we really dig pretty deep to make sure that we really just don't lay on the platitudes, but that we really try to get very specific. One of the specific things I want to very briefly mention is the importance of a social media policy. Social media has become a very tricky issue from an HR perspective. Social media policies and social media activity and online behavior of employees has always been, over the last 10 years, a hot issue. It's hotter now. People are working from home. They have more time. We're in a very politicized environment. Even wearing a mask is now a political statement. And you know, I didn't know that COVID really was affiliated as a Republican or a Democrat. I thought it really had an impact on everybody. Apparently, I was wrong. But whether or not you wear PPP, whether someone's going to wear a face mask, is now a political statement, and we have a lot of political activism going on in the country as we head into an election. The question has arisen as to how companies can regulate online activity of their employees during and after working hours. So the question that I simply want to cut to the chase right now is, do you have a written social media policy, either within or in addition to your employee handbook? If you do, then that's great. But if you don't, then A, you need one, and B, you also need to recognize that as you're regulating your employees in this regard, there's something called Section 7 protected speech. There's a very small but important aspect of federally protected speech regarding the terms and conditions and nature of the workplace and environment, which includes safety issues. In this COVID world, that's a big deal. Do you have a social media policy that deals with how to regulate this and how to acknowledge protected speech under the National Labor Relations Act? I know that that's throwing a lot at you right now, but I would just suggest and realize that when you're talking about how to manage HR resources and reputational management issues in this highly digital world, that this is an issue that you should not lose focus on. Let's proceed to the next slide, moving right along so that we don't run out of time and also leave time for questions. I'd like to just talk about in this final slide, other best business practices. We're kind of at the last stage of the PPP era. They may renew a little bit more PPP. it'll either be zero or quite limited, and it'll probably only be to small businesses that have very demonstrable, significant revenue declines. There's still almost 100 billion left in PPP round 2. It may or may not be exhausted, but you're going to be facing a PPP forgiveness window. There's going to be rules, regulations, and forms that are going to come with that. Take that to heart, because if you apply it correctly, you're going to convert the loan into a grant. Also, as to the handling of PPP funds, if you don't already have it, prepare a written corporate resolution that lays out how you use the funds, the situation as it applied financially at the time that you applied for it, so that it demonstrates the need, and how you followed it. Because if you have written policies and a written corporate resolution that backs that up, that's going to continue to add an additional layer of protection. Of course, have a written return to work policy as well. Require logins for visitors to allow for safety, maintenance, and contact tracing. One of the really big questions that's come up has been the question of waivers. And our CEO or HR lead clients say, hey, what about just having a waiver form and just telling the employees, when you come back to work, you recognize that if anything happens to you or your family, I'm going to waive any claims. And that's all good, right? And the answer is no. A waiver is probably not going to work. The inherent definition of a waiver is a voluntary relinquishment of a known right. People need to work so that they can get money to put food on the table for their loved ones, for their kids. I don't think a waiver is going to stand up in court. What I would suggest is in your policies, for example, in your return to work policy, to have an acknowledgement, an employee acknowledgement at the end that recognizes essentially, impliedly, an assumption of the risk by the employee, by the HR folks, that they know that the company is doing their best and that the company is going to exert reasonable and best efforts and practices, and that while we can't guarantee complete immunity, we're going to do our best. And I think that that's going to be a best practice. And that's really, frankly, an HR trend that I'm seeing, especially in the DC region. So I would rely on acknowledgements. I would not rely on waivers. And I would also finally encourage you to continue to make sure that you stay regularly posted with your team leads. COVID survival is a team sport. We can't do this alone. We have to come together and we have to fight through this together. So make sure that you have your policies, your practices, be ready for any kind of PPP financial audits, be ready to demonstrate that you have all these policies in place. And we very much appreciate the opportunity to discuss these aspects and practices with you. With that, I will turn it back to our fearless leader, Gary Silverman.
Sorry, I was muted there. I appreciate that whole fearless leader thing, Seth. That's very kind. We have just a few minutes left, although we'll stay as long as people like, but I like to try to keep this to an hour. So let me bring Jonathan Silverman on. Hopefully you have some questions there, John, and we can take some questions that people have sent in. I actually had a question for Mr. Berensweig, so if you don't have any questions, I'm happy to ask him one, but why don't you see what we got?
Yeah, absolutely. We actually have a few great questions to start off with. The first question is for Milt. Milt, do the courts have plans to allow remote appearance via video or via video? Milt, I think you're muted.
Your mic's not on.
Sorry about that. Some jurisdictions do. As Diana spoke earlier, the bankruptcy courts are moving on a Zoom platform, zoom.gov, I believe it was. Montgomery County, for example, and here in Maryland, has a Skype platform that they're using. DC is using a WebEx platform. So there are opportunities where certain remote hearings are going to be on a video platform. Mostly what we've been seeing is a lot more on the telephonic side. So the remote hearings will happen via telephone because not everyone has access to video capabilities. And that's not necessarily the lawyers, but the litigants on the other side. So in order to be fair, the courts are leaning towards telephone as opposed to video.
Perfect. Thank you so much. And I have another question. It kind of actually relates to it, so it's perfect. If I'm a credit union with a pending debt collection action and I'm not comfortable sending a witness to a hearing, is there anything my credit union can do?
Well, what we can do is try to file affidavits to try to get, in Maryland, for example, an affidavit judgment. In Virginia, really the only time a member of or an employee of a credit union will need to appear is if there's an actual trial. Most of the return dates in Virginia don't require witnesses. And what we've been trying to do is keep people out of court. So we've been trying to handle things via motion or via other means so members and employees of credit unions don't need to appear, and we can try to resolve these things outside of court. So we can pursue these other remedies and other options without necessarily having someone come to court, but we still want to pursue them. We can't just let them sit, otherwise we're just going to be stuck behind the backlog that is developing now and will continue to develop.
John, before you move forward, let me add a little bit to that. So obviously there are situations where we can continue cases if we need to. If there really is a situation where someone is uncomfortable coming to court, where someone cannot bring a witness to court, the option does exist to continue cases. What we are seeing with certain courts is that they are not welcoming the continuance of cases 2 or 3 times. In California, for example, where our law firm also practices, the courts there are allowing potentially 1 or 2 continuances after that. What they're telling lawyers is, well, either dismiss your case or I'll sanction you. So it's kind of a mixed bag on what courts will do. I think Milt's answer is great. The closer we can get to trial, the closer we can get to settlement. Other than that, if need be, someone may need to go to court. Otherwise, we can continue cases. There are other options. John?
Thank you both for that amazing answer. Another question is, for credit unions that have paused legal referrals, can you describe a sample reopening referral plan? I believe this is for either Milt or Gary. Either one of you can.
Yeah, I'll be happy to take that. So again, what I talked about in my segment is you don't want to be in a position where you've paused all of your referrals and you've accumulated hundreds, potentially thousands of cases. Again, the optics of referring cases during COVID may not necessarily be something that looks great. Nobody wants to get a collection letter during a pandemic. What I would suggest is it's not so much the letter they get, but the service or the discussion or the phone call they get after they get that letter. So what I would say is if you handle someone with care once they get the letter, let them know you're trying to work with them, you can actually turn that letter and phone call into a settlement where people are comfortable with the phone call they got and happy with their credit union trying to work with them, as opposed to I got a demand letter and now someone is calling and giving me a hard time about money I owe. Usually those phone calls start with why are you calling me with a pandemic and end with thank you for helping me settle the claim. Not always, but most of the time. So I would suggest that doing things now might be a little bit easier, because the optics of having 1,000 cases in the back and then sending 1,000 demand letters or 2,000 demand letters doesn't look much different than sending letters now. It really just depends on how you handle them once you send them. That said, if you do have a backlog of 1,000 cases, what you might start to think about is, do I want to batch those cases? Maybe send 200 a month. If you'd normally send 100, maybe send 200 to work that backlog. If you normally send 500, maybe send 1,000 to reduce that backlog. Batching it might be an easier way to do it. There's probably some other ways too, and we could certainly help you develop a plan, or anyone can help you develop a plan. That's just one thought.
Perfect. Thank you so much for that answer. Another question that we have is, if the repossession notice was sent before the state emergency was declared, but the car hasn't been repossessed yet, can the repossession still proceed in Maryland and DC?
Milt, can you answer that?
Yeah, absolutely. I'd be happy to. The answer is we would not advise repossessing anything in Maryland and DC until after the moratoriums have been lifted. The way the DC Emergency Act is phrased is that any collection action, including repossessions, So even though the notice of intent to repossess was sent before the emergency declaration, that would still be an act of collecting or an act of repossessing the collateral, which is prohibited in the DC and in the Maryland prohibition. So the short answer is don't do it.
That's a great short answer at the end, but a really informative question, or really informative answer as a whole. One last question. This one's also for Gary here. You mentioned the great rollbacks in other states. Have we seen courts in your coverage area roll back their reopening plans, or have you heard of any potential plans to do so?
Well, actually, as much as I like any question that's directed towards me, I'm going to let Milt answer that question because he's really covering the courts. I think the answer primarily is no, but I'm going to let him answer it a little bit in more detail.
Yeah, Gary's absolutely right. There are no signs as of yet of any rollbacks. In Maryland, we're proceeding into phase 3. Phase 4 is at the end of next month. We haven't gotten any indication that the Court of Appeals is going to push that back in Maryland. In Virginia, the decision-making is left to the local districts. So although there's, for example, a hotspot in the Hampton Roads area in the southeastern part of the state, other jurisdictions may continue to be open. So in Virginia, it's more of a localized, decentralized decision-making process, but we haven't seen anything yet. So we're going to keep you all posted if we hear anything, and through emails and other means. But for right now, it's as far as the courts are concerned, there is no rollback.
Perfect, thank you. And I believe that's those are all the questions that we have right now. So I will turn it back over to Gary.
So I'll add just to what Milt said very briefly that California and Washington, California is proceeding. We haven't seen anything rolled back in California for courts. Almost all of their hearings are being held telephonically. I think actually all of their hearings are being held telephonically. And in the state of Washington, where we're also practicing, nothing is being done at all. And there doesn't seem to be any chance of anything changing soon there as well. Before we go, I had one Seth Behrensweig question. Seth, can you give us a little bit more detail on what you had talked about, a plan, a reopening plan, an employee plan, plans for all sorts of things. Can you give us any more detail on what people should be putting into some of the, what are the key factors or what people should see in those plans when they're done?
Sure, I'd be happy to. So the plans should be a written document with an acknowledgement at the end that provides for safety protocols, relaying information, staggering attendance and social distancing, PPE, reporting protocol for any contraction of COVID, and expectations and limitations with regard to travel, various aspects as it relates to workplace safety, HR management, internal communications, and to help the employees understand what the protocol and process is going to be put in place by the company to be able to demonstrate workplace safety so that they can be assured that when they return back to work, in whatever fashion it will be, that the employer is exerting its best reasonable efforts to try to provide for a safe work environment.
Thanks, Seth. I really appreciate that. Right, well, that's all the time that we have for today. Actually, we've gone over the time that we have for today. And of course, as new information develops, it's our expectation that we'll schedule additional webinars. We really appreciate everyone joining us. And for those of you who watched it afterwards, we appreciate that as well. If you have any additional questions at the end of this event, please feel free to email, call us. Seth, just for a plug, has done a fabulous job of putting together some of these return to work policies. I would encourage you to reach out to him. If you'd like to view the webinar again or share it, it'll be available on our firm's YouTube channel, and the firm's LinkedIn page, our website. At the seminars tab, we can actually download the slides if you'd like. And in the slides as well, you'll see all the links that I talked about and Milt talked about. This is available to anyone who'd like. If you have trouble with the download, please again, contact us and let us know. Once again, thank you all. We really appreciate your being here. Be well, be safe. See you next time.